Good morning, everyone. Welcome to today's hearing. Today we're going to continue hearing evidence from Mr. Albon of the British Board of Agrément. As usual, I'm joined by the other members of the panel, Ms. Thuria Istefan and Mr. Ali Akbar.
Good morning.
Good morning, everyone.
I think my first task this morning is to check that Mr. Albon is in touch with us. I think he is, but could you confirm, Mr. Albon, that you can see me and hear me clearly, please?
Yes, I can.
Good. Thank you very much. Good morning.
Good morning.
We probably ought to just run through the housekeeping for the form's sake before we continue your evidence. Can you confirm, please, that you're alone in the room from which you're giving evidence?
Yes, I am.
Thank you. Can you confirm that you don't have any documents or other materials with you?
No, I don't.
And can you confirm that your mobile phone is in another room and that you don't have any other electronic devices with you which can receive messages?
Yes, that's correct.
Lovely. Thank you very much. Well, the procedure will be essentially the same as it was last week. We'll have a break during the morning and the afternoon. But if you want an additional break, just make sure I know that and we'll accommodate you as best we can. All right. Is there anything you'd like to raise before we carry on?
No, thank you.
Very good, thank you. Well, then I'm going to invite Ms. Grange to put some more questions to you. Yes, Ms. Grange.
Yes, thank you. Yes, good morning, Mr. Chairman. And good morning, Mr. Albon.
Good morning.
I'm going to start with some questions this morning about some of the specific wording that we see on the Reynabond certificate from 2008. And then I'm going to come on to ask you some questions about the reviews that were carried out of that certificate. So focusing first on the wording for the certificate, can we bring that certificate back up? That's BBA 6047. And we can see in the bottom half of that page, under key factors assessed and then behaviour in relation to fire, the third heading down, we see the wording in relation to the building regulations for reaction to fire, the panels may be regarded as having a class 0 surface in England and Wales. And then we also see something similar if we go to page 5 at section 6.3. If we look in the middle of that behaviour in relation to fire section, 6.3, it says, as a consequence of section 6.1 and 6.2, those are the paragraphs above that we looked at last week, the products may be regarded as having a class 0 surface in relation to the approved document B of the building regulations as amended England and Wales. Now, can we go, with that in mind, can we go to your second witness statement, that's BBA 30010723 at page 17, and I want to look at the bottom of page 17. And we can see the inquiry question in bold. And the question you're asked is, did the 2008 certificate for Reynabond architecture wall panels indicate that all such panels achieved national class 0? If not, why not? Please explain by reference to the language used in the certificate, including under key factors assessed on page 1 of the certificate. And your answer starts at paragraph 63. And if we go over the page, in a number of paragraphs there, you're basically just quoting the certificate again. If we can pick it up at paragraph 66 on that page, you say this, you say the BBA had no data to show similar class 0 low risk classifications for the standard product. And this is clear from the text of the certificate. Diagram 40 of approved document B, volume 2, sets out requirements for the reaction to fire classifications of the external surfaces of walls. In doing so, it accepts the use of either British Standard BS 476 Part 6 and 7, or European classifications using the BS EN 13501 Part 1 standard. A classification to either system could be used to satisfy the requirements of the approved document for all situations. Then you go on in 68. The two classifications require the use of different test methods and are not equivalent. the results achieved in one system cannot be used to infer a result for the alternative system. And then you go on at 69, for the situations where class naught is required, diagram 40 also accepts a classification of B, S3, D2 or better. This means that as defined in the approved document, a product achieving class B, S2, D0, as for the Reynabond standard product, could be used in all situations where a class naught result is deemed to be acceptable. In the case of the Reynabond materials, this means that the standard and FR grades could both be used in the same situations as those requiring a class naught performance, as defined in diagram 40 of approved document B. And then at 71 and 72, you say, it is for this reason that the certificate states that in relation to the building regulations for reaction to fire, the panels may be regarded as having a class naught surface. This is in respect of their permissible areas of use as defined by diagram 40. Both versions of the product met the requirements for situations where diagram 40 accepts the use of a class naught material. And at 72, you say this is not the same as stating that the standard product has a class naught surface, which had not been shown to be the case. Now, I've shown you that long passage from your statement. And you mentioned there that there is no equivalence between the European classes and the BS 476 tests, which are relevant to class naught. And it's right, isn't it, that that lack of equivalence is a point specifically made in the notes to diagram 40. Do you recall that?
Yes.
Yes. And if we understand you correctly, in your witness statement, you're pointing out that in approved document B in diagram 40, it said that either class naught or Euro class B S3 D naught was acceptable on buildings over 18 metres. Is that right?
Yes.
And that is what the BBA certificate means, is it, when it says the panels may be regarded as having a class naught surface?
I would like to point out, as I said on Thursday, that I was not involved in the drafting of this certificate, and that my statement is what I have inferred from the details on the file. So I can't be sure what was meant, but my interpretation is as described in this statement.
Yes, I understand that, and I understand what you've said about your direct involvement with the certificate. But can we agree that that is what it means when it says may be regarded as having a class naught surface? It's because of the equivalence point in diagram 40.
That's what I believe to be the case, yes.
Can you help us? Why doesn't it just say that?
I think it is a poor certificate wording and it could have been improved. The later issue of the certificate did remove that statement and made things much clearer than in the original issue of the certificate.
Yes, and when you're talking about the later issue of the certificate, you're talking about in 2017, yes?
Yes.
Yes. How would the average construction professional know that that was what the wording meant as described in your statement, i.e. not that the products are class naught, but that for the purposes of diagram 40, they can be regarded as such?
The certificate must be read in full. You cannot simply look at one phrase on the opening page and interpret from that single statement. If a construction professional had read in full the reaction to fire section of the certificate, then it would have been clear that the standard product had not been tested to achieve Class O.
Right, but you accept that certain statements, including on the front of the certificate, were misleading, is that correct? Do you accept that?
I think if taken in isolation, they could potentially be misleading, but the certificate must be read in full.
Yes. Going back to the certificate, if we can have it back up again, page 5, BBA 6047, page 5. And if we look again at 6.3, it begins with these words: as a consequence of sections 6.1 and 6.2, the products may be regarded as having a class naught surface. doesn't that suggest that the BBA has considered the results and is declaring the panels as meeting class naught?
Now, if we considered that it was a class O product, the section would have read, the products are class O surfaces, not may be regarded.
Right. Can you help us as to where that wording came from? The panels may be regarded. Was that something that was a common phrase used in the BBA at this time?
I'm sorry, I don't know.
Have you yourself ever come across that phrase in another certificate?
I haven't, but this is an area I would not normally be working in, and so it may appear in other certificates that I have not seen.
Right. Let's look at another part of the certificate. If we go to page 2, in the top section, under the building regulations as amended England and Wales, can you see that there's the second requirement down is requirement B41 for external fire spread. And we can see on the right-hand side that it says this, the panels are judged to meet the class naught requirements. Do you see that wording there?
Yes.
Doesn't that suggest that the BBA has considered data relevant to class naught and has judged that the panels meet the requirements of class naught?
No, again, if that was the case, the statement would be something like the panels are classified as class O as defined in the National Building Regulations. It would be a different statement.
I see. So are you saying it would be clear to construction professionals reading that, not that the panels are class naught, but that some form of equivalent analysis has been done?
Well, I would expect a construction professional to read the entirety of that statement, which does refer them to section 6.1 to 6.6, where the actual test data are given.
Do you accept that the consequence of saying those things about class naught was that the entire focus of this certificate became class naught right from page 1, when in fact everyone associated with it should have appreciated that the European classification results were of key importance in terms of the use of the product above 18 metres?
Again, you must read the certificate in its entirety. At the time, the European classification system was new, and the industry had for decades been used to using the Class O system. So I believe, I don't know, but I believe we were attempting to use terms that were familiar to the industry at that time.
Right. What are you basing that on, that knowledge on, that you believe you were attempting to use terms familiar to the industry at that time?
From my personal knowledge of the fact that Class O was the term that everyone understood in the industry. The European classification system was new, and perhaps people were unfamiliar with it at this very early stage. I would emphasise, though, that all of the information is given in the fire section of the certificate if the reader took the time to read the certificate in full.
Do you agree that a construction professional should be able to rely on what the BBA says about the technical properties of a product without going into the details of equivalence and testing methods?
I agree that they should be able to rely on the content of the certificate, yes. I'm not sure about the second half of your question. Could you perhaps rephrase that?
Yes, what I'm suggesting to you is that, for example, here where it says the panels are judged to meet the class naught requirements, do you agree that a construction professional ought to be able to take that statement at face value rather than have to read that together with another part of the certificate, which is about equivalence in diagram 40?
No, I don't accept that they should make any judgment based on a single sentence within the certificate. They must read the full certificate, they must understand it and read it in conjunction with the approved documents themselves. The certificate only gives information to form a judgment on the basis of the requirements of the approved documents.
Right. I think you said at the beginning of your answers this morning that it was a poor certificate wording and it could have been improved. In what way are you accepting that the wording was poor?
I would not use terms such as the panels are judged to meet Class O. I would give statements of fact. And this was not a statement of fact, it was an interpretation.
Right. Now, if we look at your second witness statement, page 28, so that's BBA 30100723, page 28. I want to look at paragraph 111. You say this: the front page of the certificate states that the panels may be regarded as Class 0 materials. If all colours of the product were covered, this would have read, the panels are Class 0 materials or similar. The use of the may indicates that this is not always the case. The space available on the front page is limited and it is not possible to give full details there. The reader is directed to section 6, which gives all of the necessary information. And then you tell us the wording was revised in the second issue of the certificate to further aid clarity. And we know that that was in 2017. Now, we will come to colour in just a moment, and we'll also come to the second issue of the certificate later. Are you saying there in that paragraph of your statement that may be regarded as Class 0 means may or may not be regarded as Class 0?
That answer was in response to a specific question about colour. So the 5 classifications given in the certificate relate to the specific colours that were tested, and I believe the certificate makes that clear.
Right, so you're saying that the extent to which it may not be regarded as Class 0 is solely in relation to the different colours, or are you saying that more broadly the certificate means may or may not be Class 0?
It certainly refers to specific colours.
And the use of the phrase may be regarded as Class 0 on the front page, which is what you're dealing with here, and then you draw this distinction about colour, is the use of the words may be regarded as Class 0 on the front page different from the may be regarded as Class 0 that we see in section 6.3, where it said as a consequence of section 6.1 and 6.2 may be regarded as Class 0?
Sorry, that was a long question.
Yes, what I'm trying to get at is whether you're telling us that the phrase may be regarded as Class 0 means different things in different parts of the certificate. Because here you appear to be telling us that the front page of the certificate is saying may be regarded as Class 0 because only some colours are covered. Whereas elsewhere in your statement, you're saying that the phrase may be regarded as Class 0 is because of diagram 40 and the fact that B may be seen as equivalent for diagram 40 purposes to Class 0. And what I'm trying to get at is whether what you're telling us is that that phrase may be regarded as Class 0 is actually being referred to in different ways in different parts of the certificate.
On the front page where it talks about maybe, I believe that relates to the 2 options within diagram 40, i.e. the European and the British Standard classification systems. The use in this answer relates to the performance of different colours potentially giving different classifications.
Yes, but if you read what you say here in paragraph 111, you say the front page of the certificate states that the panels may be regarded as Class 0 materials. And then if we go on to the third sentence, the use of the may indicates that this is not always the case.
Yes, but again, I was answering a specific question about the performance of individual colours. I was not regarding this as a question about the front page of the certificate.
I see.
Mr. Albon, before we leave paragraph 111, I'm slightly puzzled by the second sentence, which suggests that if Well, it does say that if all the colours were covered, then the certificate would have read the panels are Class 0 materials. I don't understand quite how you could make that statement if you hadn't got the necessary tests to demonstrate that they were Class 0.
I think with hindsight, perhaps I'm mixing the front page and the fire section itself, where we do talk about the fire performance of individual colours and the fact that a given performance as quoted may not be achieved for all colours of the product. It may have been better if I omitted the reference to the front page here.
All right, thank you. Yes,
Strange.
Sorry.
Yes, that's very helpful. Now, as we've discussed, Arconic did not send any information or data about test 5B to the BBA, which dealt with the cassette panels. I just want to see what you say about this in your second witness statement. So this statement at page 30. And if we pick it up at paragraph 122, you tell us this. It's at the bottom of that page. Had the BBA been aware that the cassette fixing method for the product was in fact classified as E to EN 13501 rather than B, as we were led to believe, this classification would have been given in the certificate in addition to the class B for the riveted fixing method. And then you tell us in 123 the areas of use permitted for a class E material by diagram 40 of approved document B are different than those for a class B, both in terms of height and distance from a boundary. A class E material could not have been used on a, and then we go over the page, on a building with a floor more than 18 meters in height from the ground in the absence of any additional supporting evidence, such as a full-scale fire test and compliance with the requirements of BR 135. As far as the BBA is aware, no such additional data were available as none had been provided to the BBA. And then you say this at 124, had the BBA been made aware that the cassette fixing method was in fact class E, this and the corresponding restrictions would have been made clear in the certificate text. Now you tell us that in that part of your statement, and you say something similar on at least 4 occasions in your second statement. But nowhere in that second statement dealing with this certificate do you tell us what the BBA would have said on the certificate about the class 0 if you had known that the European classification of the cassettes was class E. Can you explain to us, can you help as to what impact that would have had on the class 0 statements in the certificate?
Where there are, if you like, contradictory ratings between the British standard and the European standard classification systems in relation to permissible areas of use within diagram 40, we would always take the worst case and quote that worst case. So in this case, we would have quoted the Euroclass E and omitted reference to class O.
I see. So all references to class 0 would have been omitted, would they?
Certainly for the cassette version, yes.
Right. Even though you've still got the rivet version, which has the B, and which for diagram 40 purposes would be treated the same as class 0.
It's slightly hypothetical, but if we had been aware of that, I would have expected different classifications to be given for rivet and cassette. Potentially, we could have given both class O and class B for the riveted, but certainly not for the cassette.
Yes, you say potentially we could have given both class 0 and B for the riveted. Would the BBA still have said that the rivet fixed panels may be regarded as having a class 0 surface? Is that what you would have expected?
No, in that case, because we had test data specific to the BS 476 methods, I would expect us to give the classification.
Well, no, you had test data specific to the FR panel for BS 476, but you didn't have test data relevant to the PE panel.
Yes, you're right.
Yes. So can I ask the question again? What would you have said about the class B for the rivet? Will it still have said may be regarded as class naught?
Possibly at that time in that context, I don't know.
Yes. Just some questions now about what you say, more detailed questions about what you say about the colours that the certificate deals with. Let's just look back at page 5 of the certificate, BBA 6047, page 5. At 6.4, in the middle of that page, it says these performances may not be achieved by other colours of the product, and the designations of a particular colour should be confirmed by, and for England and Wales, it says test or assessment in accordance with approved document B, Appendix A, Clause 1. Now, if we can look at your second witness statement again, at page 27, BBA 3010723, page 27, from paragraph 104, where you're dealing with this colour point, you tell us the performance achieved in reaction to fire testing is known to be influenced by the colour of the coating finish chosen, as the pigments and other component materials can have an effect. Where the numerical result achieved places a product close to the transition point from one classification to another, as defined by the classification system, it is possible that two different colours tested could achieve different classifications. This is a general consideration for all materials and is not specific to ACM products. For this reason, the fire classification quoted in any BBA certificate is colour specific, unless the laboratory carrying out the fire test has confirmed in their report that the classification given covers all of the colours in the range. And then at 107, you go on. The BBA had only certified the fire performance of the product/colour combinations given in sections 6.1 and 6.2 of the certificate. This meant that the classifications given in the certificate were only applicable to the specific colours quoted in section 6.1 and 6.2. These classifications could not be extrapolated to apply to any other colour. And then you tell us, please look at section 6.4 of the certificate. You refer to that in 108. And you tell us that as far as the BBA is aware, no such testing or assessment was carried out on the colours chosen for installation on Grenfell Tower. The fire performance of the products installed on Grenfell Tower were not covered by the BBA certification. Now, you tell us there that the BBA only certified the product colour combinations in section 6.1 and 6.2. And if we just go back to those in the certificate, page 5, BBA 6047. Now, where you're talking about product, are you being specific about whether the product is a standard sample, the PE core or the FR core?
It would apply irrespective of the core.
Well, at 6.1, it says a standard sample of the product with a grey-green Duragloss coating. So are you saying that you're only certifying the PE version of the product with a grey-green coating and not the FR version of the product with a grey-green coating?
Yes, that's in terms of fire classification, that's the only classification that we had.
Yes. And so at 6.2, you're saying that for the fire retardant sample of the product, it's only the metallic grey colour that is covered by the certificate. Is that right?
Yes.
And we can see there are two different types of coating that are being quoted in the certificate, the PVDF coating and the Duragloss 5000 coating. Now, can you clarify for us, do you mean that the colours also have to have the same coating to be covered by the certificate? So for the top one in 6.1, it's not only got to be PE grey-green, but it's also got to have the Duragloss 5000 coating.
Yes.
And for the at 6.2, the FR sample of the product would have to be metallic grey, and it would have to have the PVDF finish, not any other type of coating. Is that right?
Yes.
So effectively, the scope of the certificate is for 3 very specific products: PE grey-green Duragloss, FR gold Duragloss, and FR metallic grey PVDF, and nothing else. Is that correct?
You said the scope of the certificate. That's slightly different. The scope of the fire classifications are as you describe, yes.
Yes, I mean, when I'm talking about the scope of the certificate, I'm talking about it in terms of its fire performance.
Yes.
Just to clarify. So you're saying that the certificate is just for those 3 very specific products, yes?
Yes.
Doesn't that limit the certificate enormously to the point of almost uselessness if it only applies to those specific colours and those specific coatings?
Yes, it does. Very often a fire classification report is provided which does cover the full colour range. In those circumstances, the certificate wording would be different. This does require that for a particular installation, the colour and the configuration to be used on a building must be tested in order to determine its reaction to fire classification, and therefore its suitability for that particular installation.
Right. Well, let's just test that a little and just look at some other points. If we go to page 3 of the certificate, under the heading, the second heading down, technical specification, at 1.1, we can see that it tells us, yes, if you look in the 3rd line down, there's the word A at the very end of the line on the right-hand side. It tells us in this description that a Duragloss or PVDF coating available in various colours protects the exposed face. And we saw in the evidence of Mr. Gregorian that this particular statement was inserted at the request of Arconic. Now, wouldn't the reader of this part of the certificate understand this to mean that the Duragloss or PVDF coating in whatever colour was covered by the statements made in this certificate?
Well, the performance in other aspects is covered by this certificate. Its light fastness, its structural performance, and various other performance parameters are not affected in the same way as the fire classification. Again, you must read the full certificate.
I see. So you're expecting somebody to read that sentence there, a Duragloss or PVDF coating available in various colours protects the exposed face, but to understand that in the fire performance section, what you're saying about fire performance only covers very specific products and very specific coatings, yes?
I think, is it section 6.4 makes it very clear that this fire performance is not achieved by other colours, or may not be achieved by other colours of the product. I do think that is quite clear.
Yes. You say in paragraph 104 of your statement, we just looked at it, that 2 different colours could achieve different classifications if the numerical result is close to the transition point from one classification to another. Do you remember where we just looked at that just now?
Yes.
Can we go to an email chain? This is BBA 3010693. This is an email chain between you and Mr. Gregorian in October 2007. And if we go to the second email down on the first page, this is from you to him. And we can see in the 3rd paragraph, so you said, Hamo, I think your wording is generally appropriate. And this is just to be clear about the Alcoa Rainabond cladding panels. And then you say something about durability in the 2nd line. And then in that 3rd paragraph, you say, I don't know what statement you are making on fire performance, but it is now our policy that reaction to fire testing is colour specific, i.e. that if you have a fire test report for a particular colour, then the results only apply to that colour, not the full range. You can't say that the whole range is class 0 low risk, for example. Now, it's right, isn't it, that no one at the BBA considered whether these colours were close to the transition point between classifications, did they?
No.
This was just standard wording that was inserted upon your instruction, wasn't it?
It was my advice, not my instruction, but yes.
Yes, your advice then. And it's not inserted for any technical reason pertaining to Reynabond. It's just BBA policy to make that colour caveat clear at the time, yes?
Yes.
What had led to the change in policy that you're referring to in that email? You say it is now our policy that reaction to fire testing is colour specific. What had led to that change?
At this time, I was section head of a different department dealing with paints, coil coatings, products where colour was really quite important from an architectural perspective. I had been advised, I think initially by Exover Warrington, that colour could make a significant difference to the classification achieved by a product. I was surprised by that, and I subsequently raised it with BRE for confirmation, and they did confirm that this was the case. So once I had that information from 2 UCAS accredited fire laboratories, I made the rest of the BBA aware of that position.
Right. And can you recall who was it at the BRE that you spoke to about this point?
I can't be sure, it was 2007, probably Sarah Colwell, but that's not a statement of fact. She was my usual contact. It may have been someone else.
And can you help us? What kind of test or assessment was the BBA recommending should be carried out by construction professionals on different colours of a product?
It would be the process defined in the approved documents, so BS4, the British Standard, BS 476, parts 6 and 7.
I see. So just stepping back from this, is it right that the BBA was keen to limit the certificate in terms of colour, but not, and fire performance, but not in terms of fixing method, i.e. cassette, rivet?
Well, the certificate is an assessment of overall fitness for purpose, of which fire is only a part, albeit a very important part. The only applicable restriction in this case would have been the fire classifications.
Yes, but what I'm getting at is isn't this a potentially inconsistent approach to be limiting the certificate in terms of colour, but not making clear that the results that you're quoting for fire performance were for the rivet and not the cassette?
Yes, I think I acknowledged on Thursday that we should have included the facts that those fire test reports were specific to the riveted product.
Yes. So can we agree that this is an inconsistent approach to be saying on the one hand that it's limited by colour, but not to say it's limited by fixing method?
No, I think it's two different things. The colour is a deliberate policy imposed across all product types by the BBA. The failure to refer to riveting is an error.
I see. Now, the reality is that Reynabond came in a plethora of colours and finishes. Now, it's right, isn't it, that the BBA project managers would have known that, having reviewed the Reynabond marketing literature, yes?
Yes.
But despite that, this certificate has extremely serious colour caveats, reducing its usefulness to just 3 very specific products. Is that right?
It does have those caveats. I'm not sure it reduces its usefulness because it instructs a potential specifier to obtain the necessary fire classification for that configuration and colour.
Right. If we go back to the email chain that I was just looking at with Mr. Gregorian, BBA 30100693, and just look at the top of the page. Mr. Gregorian, in response to your advice, he says, thanks, John, I'll change the text refire and have a chat with you later. Regards, Hamo. Now, as to that, do you recall reviewing or commenting on the text of section 6 of the BBA certificate prior to that certificate being issued on the 14th of January 2008?
No, I doubt I would have done so.
Why do you doubt you would have done so, given this exchange?
Because I was working in a different team within the BBA and I was not advising on the detailed text of the certificate other than this email, which was a general policy across the business and not specific to this job.
Do you recall having any other discussions with Mr. Gregorian about the text of section 6 of the certificate before it was issued?
I may have done, but I don't recall.
Okay. Now I'm now going to turn to ask you about the reviews of the certificate that were carried out subsequently. We heard in the oral evidence of Ms. Valentina Amoroso that there were a number of reviews of certificate 084510 during its lifetime. And we've understood the chronology, just to help you with that, to be broadly as follows. There was a review which started in December 2010 and closed in April 2011. That was the 2011 review. There was then a second review which started in October 2013 and closed in April 2015. We're going to call that the 2015 review. The BBA then offered a reissue contract to Arconic, but this was not processed by the BBA despite being signed by Arconic. Then there was a review which started on the 12th of October 2016 and went through to November 2016. That's the 2016 review. And then the BBA again offered a reissue contract to Arconic in 2016, and that was taken up. And the fire at Grenfell Tower occurred during the work being done on the certificate during that 2016 reissue contract. So that's the background. Now, in terms of the terms that applied to these reviews, can you just help us with this? We see in the documents that have been disclosed about the reviews that there were from time to time additional terms and conditions that applied specifically to them. We have sought clarification with this from the BBA as to precisely what conditions would have been applicable to the reviews. And we understand the BBA's position to be that there were additional terms and conditions for the reviews, but that the original contract terms entered into in 2007 would have remained in force for the lifetime of the certificate. Is that correct? Is that consistent with your understanding?
Yes, I believe the review terms and conditions refer back to the original.
Yes, so proceeding on the basis that the 2007 contract terms applied to the reviews, can we just return to those terms and conditions in the technical file for this assessment? This is at BBA 408042 at page 2. So these are the certificate terms and conditions. This is taken from the file that we have for this Reynabond certificate. And if we go to page 3, we see the clause 7 obligations upon Arconic. We can see those on the left-hand side, on the left-hand column. And we can see that under 7A, there's an obligation to disclose to the BBA full particulars of and relating to the subject, including, and then there's a whole list of particulars that have to be provided. And then if we look at clause 7G further down in that column, we can see that it was an obligation of the main contract to immediately notify the BBA of any change in the particulars supplied to the BBA or any third parties, and also of any new or additional information concerning the subject or its suitability for the specified use, including, without limitation to the generality of the foregoing, details of claims by users of the subject that is or may be unsatisfactory for the specified use. So those are the main contract terms. And if we could also look at page 4 of this certificate, sorry, of this contract, we can see on the left-hand side at the top is clause 13. And this deals with withdrawal or suspension of the certificate. And it makes clear that the BBA shall be entitled to withdraw or suspend the certificate at any time by notice in writing to the applicant. And then without prejudice to the generality of that, may withdraw or suspend the certificate by notice. And then there are some particulars given about certain circumstances, including, for example, at B, there's any change in the technical specification of the subject as assessed and set out in the certificate. So that's the contractual provision that governs withdrawal or suspension of the certificate. Now, just in general, would you agree that a review should be a thorough and comprehensive process?
Yes.
And would you agree that a meticulous and careful review process is essential to the trust that the construction industry has in BBA certificates?
Yes.
Now, I want to focus with you at this point on the review that took place between 2013 and 2015. Now, as we heard from Ms. Amoroso during her oral evidence, this commenced in October 2013, when the former project manager, Maria Barbato, wrote to Arconic. If we can look at her letter, that's at BBA 408090. This is Ms. Barbato's letter, 8th of October 2013. And if we go to page 2 under the heading submission of data at the bottom of that page, it's stated, it is necessary for the BBA to be supplied with the following information in order to carry out the review of your Agrément certificate. And the number is given. And in 1, it says it's the normal practice to do a written survey of users of the product. And there's a typographical error in there referring to stone-like cladding panels in the second line. And then we see it, paragraph 2, written confirmation that there have been no changes in the design, specification, context of use, or other details that would invalidate the certificate. Alternatively, please specify any changes. And then it goes on about factory production and control in paragraph 3. And regarding factory production and control, they are asked for full details of any changes to, and then a whole list. We see raw materials, and then if we go over the page, the manufacturing process, quality control procedure. And then the list goes on. We don't need to go to the other items in the list. And we can see this is signed Maria Barbato. So that was October 2013. And do we take it from that by this time, so October 13, and I think by this time you're head of approvals of construction products, is that right? You held that position between 2013 and 2019.
Yes. There was a brief period where I was head of approvals for the energy and ventilation team, and I believe that's missed from my statement. That was for a brief period before the 3 teams were merged into 2 teams, at which point I became head of construction products. So my statement wasn't entirely correct in terms of chronologically.
I see. Can you remember the date when you became head of construction projects?
I think it was 2013, but not precisely.
Right. Now, do we take it from this that by this time it was customary to require a certificate holder at such a review to provide both factory production control data, that was paragraph 3, and the written confirmation, if we can go back a page in the letter, the written confirmation that there have been no changes that we see in paragraph 2. Was that customary practice within the BBA?
Yes.
And we saw in the evidence of Miss Amoroso that she sent similar versions of this letter herself, or sent a similar version of the letter herself. For the transcript, the reference is at BBA 408098, and that also contained an identical request for written confirmations that there have been no changes in the design. And then we saw that the project managers sent a number of requests for this information over a protracted period. That's between October 2013 and January 2015. Ms. Barbato herself sent 6 requests in writing and also had several telephone calls. And Ms. Amoroso and Mr. Nakomo sent 5 written requests. So in total, that's 11 written chases in that period. Now, was that volume of correspondence on this review normal in your experience?
No.
Didn't it indicate to the BBA that it had a recalcitrant certificate holder?
I would have expected more of a response after that number of chases, yes.
Yes, not just more of a response, but a response, yes, because you had no response to that.
Yes.
Didn't it indicate that Arconic weren't interested in sharing information with the BBA?
Certificate holders very often were slow to respond for requests for information. This is not unique or even an unusual situation at that time.
I see. So you've accepted that the volume of correspondence on this review was not normal, but you're saying that this was not a unique or an unusual situation. Is that right?
It was common for certificate holders to be slow in responding. This is an exceptional, an extreme case, I believe.
Right, you say it was common for certificate holders to be slow in responding. What about no response at all to that question posed and again 11 times?
Again, it was unusual, but not unique. In these situations, it was to the discretion at that time of the line managers whether enough information was available elsewhere to enable a judgment to be made as to whether or not the certificate continued to represent the performance as assessed.
Right, well, I'll come to the decision that was made about this in just a moment. What we know is that Ms. Amoroso did succeed eventually in establishing a signed quality plan and setting up some ongoing surveillance, but she did not succeed in getting the written confirmation that there had been no changes which would invalidate the certificate. Can we go at this point to an email she sends in January 2015? This is at BBA 408079. This is the email from Miss Amoroso to Lilia Koskuk at Arconic, copying in Mr. Verla and Celine Ernie. And she says, "Hi Lilia, sorry for the late reply. Unfortunately, in the last year, we've experienced several problems getting in touch with you and receive the required info to progress our job, this leading to severe delays in closing this review job. For this reason, BBA has decided to go ahead with the information already in hands." And then she says, "I drafted a copy of the review report and I'm awaiting for approval from my team manager. After that, you will receive it for your personal record." Now, did you have any role in the decision to go ahead with the documents already in hand at this point?
I don't think so. This would be in the engineering department, so it should not have been involved.
I see. Do you agree with this decision, given the history that I've just outlined to you, which we went through with Ms. Amoroso in detail?
I can't really make comments because I don't know what information was available from other sources that led to this decision being made.
But hang on, you know that the manufacturer has been asked at least 11 times in writing for confirmation that there have been no changes undermining the certificate. How could information that you do have in your hands affect the fact that you are missing that important confirmation?
I don't know what information was available. I would imagine that technical literature performance claims were examined and that there was no contradiction in the claims being made by the manufacturer compared to those made in the certificate. That would have given reassurance that nothing had changed. At this time, there was discretion given to team managers to proceed in this way. I would have expected the team manager to speak to his boss, the head of approval. Certainly in my team, that was how it worked. And so a decision would have been made at a senior level within the BBA that sufficient information was available. We have changed the process now, and this discretion no longer applies. In these circumstances, under the current processes, the certificate would be suspended.
Yes, well, thank you for that. But going back to what you said about the situation pertaining at the time, you said there that there was no contradiction in the claims being made by the manufacturer compared to those made in the certificate. The BBA's job didn't start and finish with the claims being made by the manufacturer in its literature, did it?
No.
The BBA's entire purpose, surely, was to scrutinise such claims and ascertain, by reference to objectively verifiable evidence or information, whether those claims were accurate, yes?
Yes, but the decision had already been made in the original assessment based on data provided to us that appeared to validate the claims being made. I don't think the BBA procedures were ever designed to cope with a situation where a manufacturer would deliberately mishold fire test data from the BBA and continue to do so.
But put aside for a moment what had happened when the certificate was first issued, we know that Arconic came into possession of more fire test information in the ensuing years, information which did undermine that was in the certificate. Why wasn't it important for the BBA to get an answer to the question whether anything had changed?
Given the fact they had already misrepresented the performance of the product and were continuing to do so despite the fact they had additional fire test data, again, our procedures did not envisage such a situation could occur, that someone could behave in this manner and deliberately mislead us.
But with fire test data, wasn't it envisaged that there could be retesting of products periodically, as we've seen in some of the underlying fire test information, where it recommends that tests are carried out at intervals to check whether the information still remains valid?
Yes, that's true. And if that were the case, then I would expect that a responsible manufacturer would immediately change the claims being made for the process based on the new fire data available to them. I'm assuming that they did not do so because we would have checked that as part of the review process.
Right, but here you haven't just got a void, an absence of information. You have 11 requests where you've asked for that information. You've asked whether there have been any changes. That should have been a very simple thing for Arconic to answer, shouldn't it?
Yes, it should.
And you've had those 11 requests go by and they haven't said anything to you. Shouldn't that have alerted suspicion within the project managers that something was awry?
Well, again, we may well have been naive, but I don't think that suspicion that someone was deliberately misrepresenting the performance of their product in a safety critical manner would have occurred to us.
Mr. Nakomo said that there was a general instruction in place that if project managers were not getting all the information that they'd been chasing for, that project managers should then complete the review with what you have and close the job. That was his evidence at day 107, page 48, and lines 54 to 55. Sorry, and pages 54 to 55. Were you aware that this was the approach that project managers were following at this time, to complete the review with what you have and close the job and move on?
I think Mr. Nkoma may have accidentally slightly misinterpreted the position. I would have expected him to discuss that situation with his line manager as part of regularly monthly updates, and that they should come to a decision between the two of them to close the job on the basis of the information available. That was my experience.
I see. I understand what you're saying in terms of the process he should have followed. He perhaps should have gone one level higher than himself. But in terms of the basic point that he's making, he said there was a general instruction in place that if project managers were not getting all the information they've been chasing for, that then they should complete the review with what you have and close the job. Are you suggesting that he's making that up, or was that indeed the general instruction at the time?
No, I'm not saying he's making it up. I think he's just slightly not given all of the full information. Certainly the intention was to close the job if possible, but only if the information available to him was such that he could have confidence in closing that job. It's a case-by-case process. It's not an overall instruction.
And how was that communicated to project managers and managers such as Mr. Nkoma?
Through training, ongoing mentoring, and the fact that there would be a minimum of monthly meetings initially between the project manager and the team manager to discuss all ongoing jobs. And then the team manager would meet with the head of approvals in the same way to discuss problem jobs. So in that scenario, I would expect that this would have been discussed with the head of approvals and a decision made on an individual basis that it was appropriate to close the job.
Right, but it would appear that didn't happen in this instance, yes?
I don't know.
Did you endorse that approach, that general approach of if you can't get all the information, you just complete the review with what you have and close the job?
At the time, yes, that was consistent across both teams. As I said, we have perhaps recognised that we were naive and changed the process as it stands at the moment.
Right. Ms. Amoroso said that it was the common practice within the BBA that suspension would only happen where there was, in her words, active denial from the certificate holder to allow factory visits. That was at day 106, page 82, lines 16 to 20. Is she right about that? Was it common practice that suspension would only happen where there was active denial to allow factory visits?
I think she's incorrect. That is a scenario where suspension would certainly happen, but there are many other situations where certificates may be suspended.
Can you explain how that came to be her understanding of the circumstances and indeed the only circumstances in which suspension would occur?
No, I can't.
Was there any written policy or guidance to project managers about when a failure to communicate with the BBA should be escalated?
This would be discussed on an individual basis in the meetings that I have described.
When you say this would be discussed, do you know for a fact that it was discussed on a regular basis at the time, or is that speculation on your part?
It's speculation on my part. I can only speak from my own personal experience of the way matters were managed in my team. The intention was that it should be consistent across both teams. Our procedures are consistent across both teams, and I would be surprised if that were not the case. I don't have personal experience to confirm that, though.
So when I asked you the question, was there any written policy or guidance to project managers about when a failure to communicate with the BBA should be escalated? Is the answer to that question no?
I can't recall a specific policy that would cover that scenario. but every job that we do is handled on an individual basis, and it is discussed with line management, who are familiar with the processes, as are the project managers.
Was there any written policy or guidance given to project managers about when to escalate a case for consideration for suspension? Again,
at an absolute minimum monthly basis, each job would be discussed with the line manager, and scenarios for handling individual situations will be developed.
Who are you saying would have been the line manager that this should have been discussed with? Who was that at the time? This is
the head of approvals. I'm sorry, I spoke over you. It would be the head of approvals, Brian Chamberlain.
Right. But again, I think the answer to my question is no. Is this right, that there was no written policy or guidance given to project managers about when to escalate a case for consideration of suspension?
There are documented procedures dealing with the suspension of certificates. Policies cannot possibly cover individual circumstances because they are subtle and nuanced and have to be discussed.
And when you say there are documented procedures dealing with suspension of certificates, are you saying that those written policies don't cover at all the circumstances in which suspension ought to be considered or escalated within the BBA?
That's a subjective consideration that is very difficult to actually put into a procedure. So no.
Ms. Amoroso has also said that she did not review the original contract terms with Arconic to see what they said during this time. Can you explain that? Why a project manager wouldn't go back to the contract terms to see what the overarching obligations were in this scenario?
I'm struggling to see why a project manager would go back to the contract terms. The requirements for the review are clear. There is a standard review letter. The standard review letter was sent. The consequences for failing to comply with that, as I say, would be discussed with line management. I don't really see it's necessary to go back to the terms and conditions of the certificate.
Well, in circumstances where 11 separate chasers had been sent for confirmation that there'd been no changes undermining the certificate, wouldn't you have expected the project manager to have reviewed the contractual obligations in their entirety in order to start considering suspension?
I think as part of the training, the contractual obligations are understood by project managers. I don't dispute that. I just wonder why anyone would need to go back to read the original contract. It's the principles, I think, that are important, and they would have been understood.
Well, one possibility is so that they understand the circumstances in which suspension or withdrawal of the certificate can occur.
But that would not be a decision for the project manager. There is an escalation process within the BBA that ultimately requires the signature of a director. There were about 4 steps in the suspension, and it's not the project manager's decision.
Right. So how do you suggest this ought to have happened? That the project manager escalated this to Mr. Chamberlain for consideration of suspension? Yes.
No, I'm saying it would depend on the individual circumstances, and I am not aware of what those circumstances were and the basis for the decision that was made. If it was considered that it was appropriate to suspend the certificate, then there is a process to be followed, and that would ultimately involve the head of approvals.
Okay, but you are aware, and we've gone through it in detail with the BBA witnesses, that on at least 11 occasions, written confirmation was requested that there were no changes undermining the certificate. In those circumstances, would you have expected the project manager to have considered suspension and referred it to her line manager for further consideration?
Yes, I would expect this job to have been discussed as with any other job and an appropriate decision made.
Why do you say I would expect this job to have been discussed as with any other job? Wasn't this a very unusual situation where those requests had been made time and time again over a 2-year period with no response?
Yes, it was an unusual scenario, although not unique. all jobs are discussed on a regular basis with line management and decisions made on the basis of the available information.
To your knowledge, was there any pressure on the BBA project managers to close out reviews? Were they incentivized to close out reviews?
As with any business, there is pressure to complete work in hand. When you say incentivized, no, there's no financial or personal reward to be gained by closing jobs.
What about pressure at around this time? Were you conscious that there was pressure on project managers to be completing and closing out reviews?
As with any business, as I say, there is always pressure to complete work in hand. I'm not aware of any particular emphasis at this time.
The reality is, isn't it, that the BBA is a commercial organisation, so the longer a review takes, the less profit the BBA will make on the fees that the certificate holder is paying. Do you accept that?
It doesn't affect profits. The fee is a flat fee for a review. I should emphasise, yes, there is commercial pressure to complete work. That is never overriding the technical integrity of what we do. That is always paramount.
Were you ever made aware that there was a leaderboard or tally in the BBA office showing the number of closed out reviews for each team?
No.
You were never aware of that at any stage?
No.
Now, we know now that by this stage, Arconic had further fire test data. In October 2011, Arconic had performed another European test of the Rainabon PE in cassette form. And this time the CSTB issued a classification report saying that cassette form was a class E. Then more tests were done at the end of 2013. And on the 31st of January 2014, the CSTB issued a classification report that Rainabon in either rivet or cassette form was class E. So all Rainabon panels were European class E. That is the time when Miss Maria Barbato was seeking information from Arconic. That classification of E for both panels lasted for the better part of the year. And then on the 4th of December 2014, at Arconic's request, the CSTB issued new classification reports. The Rainabon PE rivet dropped from a class B and was classified as a C, S2D0. And the Rainabon PE cassette was classified as E. Now, in those circumstances, it's right, isn't it, that had the BBA insisted that Arconic produced written confirmation that there were no changes undermining the certificate, the BBA might well have been alerted to the fact that the fire performance was wrongly stated on the certificate. Do you accept that?
If they had told us, yes, but I would have expected them to provide us with those fire test reports in accordance with their contractual obligations. I would also have expected them to update the fire classifications being claimed for their product in their technical literature.
Yes, but I think we can agree also, can we, that you would have also expected the BBA to have insisted on confirmation that there were no changes which invalidated the certificate.
I think given the history of communications with Arconic, I would very much doubt they would provide us with that information. But if they had done so, then yes, it would have alerted us.
Can we just look at what you say about this in your second witness statement? That's BBA 30100723 at page 34, paragraph 138. You say there, 138, as previously described in point 21 above, no response was received from the certificate holder to these requests for the first two reviews. As much of the necessary information was available to the BBA from other sources, such as the internet, a decision was made to continue the certification on the basis of the information that was available, on the understanding that there had been no significant technical changes affecting the certificate. Then you go on, BBA procedures do allow sanctions to be taken. For example, when there is a lack of cooperation by certificate holders, and this could lead to suspension or withdrawal of a certificate. However, on my review of the documents in this case, I can see no reason to believe that there was any additional information conflicting with that given in the certificate. In addition, the certificate holder was continuing to cooperate in other ways, such as maintaining the surveillance operated over the manufacturing process. It seems to have been considered at the time that withdrawing the certificate would be a disproportionate response to the lack of communication from the certificate holder during the review process. Now, can you explain, in circumstances where Arconic had been asked on multiple occasions to confirm that there had been no changes which would undermine the certificate and had never responded, why you are saying there that it was considered that withdrawing the certificate would be a disproportionate response to the lack of communication?
Well, that was a conclusion drawn by other people, so I can't comment on whether or not it was appropriate. I can only imagine that the information available at the time gave the necessary reassurance that there was no contradiction between the performance being claimed and that was given within the certificate.
Well, they were not cooperating in a significant way with the review, were they? We can agree that.
Yes.
And if they couldn't confirm there'd been no changes, you could have no confidence that your certificate was an accurate statement about the performance of the product, could you?
Well, it was consistent with the claims being made by the manufacturer.
Why did that give you confidence that the certificate was an accurate statement about the performance of the product?
Well, as I've explained, I don't think our procedures anticipated a situation where there would be deliberate misrepresentation of the performance of the product with a fire safety critical aspect of performance such as this.
But if all you're doing in these reviews is looking at whether there's any changes as compared with the manufacturer's literature, what is the point of a BBA review? Couldn't an average construction professional do that for themselves?
Well, the review goes beyond looking at the manufacturer's literature. That's only one aspect of it, but there was no information available to us that suggested the assessment made during the original contract was incorrect and that nothing appeared to have changed.
But you'd asked that very question of the manufacturer, and on multiple occasions they had not responded. So you did have some information available to you that suggested there might be a problem, yes?
Yes, there could be many reasons why there was no response though. As I've said, perhaps we were naive, but I don't think we anticipated the actual reason why there was no response.
Mr. Nakomo's oral evidence, he was the team manager at this time, was that he was not even aware that there was any discussion or consideration of suspension of the certificate. That was day 107, page 69 and page 90. How can you explain why suspension doesn't even appear to have been considered as one possible response to the lack of cooperation you were getting from Arconic?
I don't know, I was not involved in that particular conversation.
Mr. Chairman, if I can just finish this line of questioning, it won't take much longer.
Yes, all right.
If we look at your another passage in your second witness statement at page 35, paragraph 142. You say this, you say the failure of Arconic to disclose the existence of other fire test reports, including that demonstrating Class E performance for the cassette fixing method, should have been declared to the BBA at the time of the initial assessment and at each of the subsequent reviews. The failure to do so prevented this classification being included in the product certification. And then you say this, we would clearly consider this to be unsatisfactory now, but could have formed no opinion on the matter at the time of receipt of their response, as we were unaware of the existence of the additional data. Now, in that last part of that paragraph, doesn't that actually underestimate what was going on here? You say you could have formed no opinion on the matter at the time. Couldn't you have formed an opinion on the fact that Arconic was failing to cooperate with the BBA by failing to respond to its requests?
Yes, and we have now changed our procedures whereby where no response is received, we will proceed to suspend the certificate.
The implication from your statement is that you didn't consider that to be an unsatisfactory state of affairs. Can you explain why not?
Well, clearly it was an unsatisfactory state of affairs. As I've said,
Sorry.
I am assuming that at the time, the individuals concerned considered that there was sufficient information available to them to make a judgment.
Wasn't this the paradigm case of a lack of cooperation?
Clearly, there was a lack of cooperation. For context, it was not unique. This would sometimes happen, and a judgment had to be made on a case-by-case basis.
Can you accept now that that was a wholly flawed judgment that was made at the time?
Yes, and for that reason, we have now changed our procedures so it cannot reoccur.
And shouldn't the BBA have suspended this certificate until Arconic provided all of the information that had been requested?
That was not the policy at the time. It would be the policy now. Why that was not carried out at the time, I don't know, because I don't know the individual circumstances.
I see. Mr. Chairman, thank you for letting me carry on. I think that would be an appropriate moment.
Yes. Right, thank you very much. Well, Mr. Albon, we'll have a break at this point. We'll come back at 20 to 12, please. And again, as I have on previous occasions, I have to ask you not to talk to anyone about your evidence or anything relating to it during the break. All right?
Yes, thank you.
Good. We'll look forward to seeing you a bit later on then. Thank you very much. Welcome back, everyone. We are ready to continue hearing Mr. Albon's evidence. I'll just check that he is in contact with us. Are you there, Mr. Albon? Can you see me? Can you hear me?
Yes, I can.
Very good. Thank you very much. You ready to carry on, I hope?
Yes.
Good. Thank you. Then when you're ready, Ms. Grange.
Yes, thank you very much. Mr. Albon, just some short questions now about the CSTB. And we want to know if you can help us with a matter which arises from Ms. Amoroso's evidence on the CSTB. She said in her oral evidence that she would have expected the CSTB to notify the BBA if there had been changes to the certified product. She said that at day 106, page 79, and also page 206 and following. And she talked about a mutual agreement between the BBA and the CSTB in this regard. Now, can you help us? Was there any mutual agreement between the BBA and the CSTB about the sharing of information relevant to, for example, the Reynabond product?
Not in the way you have just described, no. Other than the CSTB providing us with data during the original assessment, that was the end of the relationship with regard to Reynabond. Right,
thank you. And there was some supposed to be some sharing of information relevant to the surveillance of the factory processes, which the CSTB was to be carrying out and which the BBA relied on up until 2015. Is that right?
Yes.
And that's what Mr. Nakomo appeared to understand this agreement to relate to. He thought it was about the surveillance visits, which the CSTB were undertaking. That was day 107, page 23. So just to be clear, is your evidence that there was no agreement with the CSTB to share test evidence or data more generally than that?
Not that I'm aware of, no.
Yeah. So you're not aware of an agreement with the CSTB to share information relevant to the Reynabond products if, for example, they were retested by the CSTB between 2008 and 2015?
No.
Thank you. Now, moving forward in time to the 2016 review, we heard from Ms. Amoroso about that 2016 review, which commenced in October 2016. Can we just go to the letter that she sent at that point? This is BBA 3011059. And if we go to page 4 within this string, we can see, yes, thank you. Is that there? Yes, here we can see the email that she sent on the 12th of October 2016 to Mr. Verler, Mr. Schmidt and others at Arconic. And she says that it's about the Reynabond architecture wall cladding panels and this certificate. She says, I've been designated as the project manager responsible for coordinating the review of your BBA certificate. And she gives the number, and your name has been advised to me as our main liaison contact for this work. And then you can see what she says is underneath that. Our estimated time for the completion of this project is approximately 4 months. And to initiate the work required for this review within that period, we require the following information to be provided to the BBA by Alcoa Architectural Products. And then she says at point 1, written confirmation from Alcoa that there have been no changes to the raw materials, manufacturing process, or quality control procedure other than those already notified to the BBA. Then at point 2, she wants a copy of the current UK technical literature and CE marking if applicable. At 3, a list of customer complaints. At 4, recent copies of quality control sheets. And then she says, in order that there are no delays, I'd be grateful if you'd reply with the relevant information. Now, that is different from the letter which Ms. Amoroso sent in 2014 in the sense that it does not request written confirmation that there have been no changes in the design specification, context or use or other details that would invalidate the certificate. Now, we've understood from the evidence of Mr. Nakomo that this email that we see on the screen would not have been a standard form letter, but a letter that the project manager would have taken from something working on at the time. Is it right that it was up to the project manager how to phrase the requests for reviews at this time? So we're now in 2016.
I was not directly involved. It was my understanding there was a standard review template. I know for sure there is a standard review template now. I thought there would have been at this time.
So would you have expected to have seen the same paragraph about written confirmation, no changes, repeated as part of this 2016 request?
I'm sorry, I'm not familiar with what the standard templates would have been in 2016, but I'm surprised it's not there.
Yes, thank you. Now, in fact, so Arconic responds to Ms. Amoroso in terms. First, Mr. Remy provides detailed information about the surveillance quality plan. And Mr. Amoroso then asked for UK technical literature and CE marking, etc. And Mr. Remy sends her some technical data sheets, a brochure about installation and the CE certificate, albeit for Rainolux. And we can find no other communication in which Ms. Amoroso asked for any kind of confirmation that there were no details that would invalidate the certificate. Now, can you tell us whether that was in line with the BBA's formal processes and procedures at this time?
I'm sorry, I don't think I can, because I can't recall the template that was in place at that time.
Right, so you can't recall what should have been requested?
No, sorry.
I see. Now, we heard in the oral evidence of Ms. Amoroso that at this time she noticed that Arconic were not taking responsibility for the product when fabricated in cassette form, and she required all references to that to be removed at this time. Doesn't it follow from that change that the BBA did appreciate that the original certificate did cover the cassette variant?
I think that is open, unfortunately, to interpretation. It's not to my view, but clearly other people thought that it did.
That change was a very important one, wasn't it, to remove references to the cassette fix, because otherwise people might think the performance stated was accurate for the cassette fix, yes?
Yes.
Wasn't that something that needed to be updated as a matter of urgency?
I think the urgency would only apply if we had been aware of the reaction to fire classification of the cassette product, and we weren't.
Why wouldn't the urgency apply also once you became aware that Arconic was not taking responsibility for the product when fabricated in cassette form?
Well, that was something we clearly needed to address, and I believe we did so as part of this process. But clearly the urgency to that would be less than it would be for a safety critical parameter.
Right. Well, what we see is that the next step was for Arconic to enter into a review contract, and that change was brought about over a period of months. Can you help us as to whether that was in line with the BBA's standard processes at the time?
I think you mean reissue. This would be the review, but if it was a reissue contract, the time to carry out the reissue would vary depending on the amount of work involved and the nature of that work.
And does it follow that during that time, you could have a certificate remaining in circulation, but which you know you want to make a change to narrow the scope of it?
Yes.
Now, I now want to ask you some questions about the BBA's decisions around this time, about the relevant regulatory regime governing these ACM panels. And if we can look at your second witness statement at this point, BBA 30100723 at page 24. want to look at paragraph 95. Now, in this section of your statement, just for context, you're dealing with the 2016 review of the certificate. And you say at 95, it was also noted that the fire section required updating to include reference to the necessary height and boundary restrictions. This was part of a general change of BBA policy to give the BBA's opinion on the interpretation of the requirements of the documents supporting the national building regulations. This did not represent a change in the nature or scope of the assessment or certificate, and would not have imposed any additional restrictions on the use of the product defined in the national building regulations as originally assessed. And then you say, please see paragraph 149 below for further details. And if we go on to paragraph 149 on page 36 of this statement, you say this, it's right at the bottom of the page. You say earlier in 2017, before the fire, the BBA had identified what it considered to be an ambiguity in the wording of section 12.7, insulation materials, products of approved document B, volume 2. And then you, over the page, you say this section reads, and we get the quote from 12.7 of approved document B. And then at paragraph 150, you continue, the issue centered on what would constitute a filler, and in particular, whether the polyethylene materials in ACMs could be so classified. Since the events at Grenfell Fire, there has been some debate on this issue, and an opinion has been expressed by an expert witness to the inquiry, Dr. Barbara Lane, that this is not the case. However, the BBA felt that the existence of the etc. in this section widened the definition of the materials covered by this requirement, and that it could be concluded that the polyethylene would be required to be of limited combustibility, irrespective of whether or not it constituted a filler. And just to finish this point, you say at 151, if this was the case, as the polyethylene was not of limited combustibility, the product would be restricted to use on buildings up to 18 meters in height. And just to be clear, that you say in the middle of that paragraph that the BBA felt that the existence of the etc. in this section widened the definition. We can see that at the top of the page where it reads, in a building with a story 18 meters or more above ground level, any insulation product, filler material, not including gaskets, sealants, gaskets, and similar etc. used in the external wall construction should be of limited combustibility. Now, taking this in stages, can you explain when was this ambiguity in the wording of 12.7 as you have characterized it, first identified by the BBA?
Not precisely, around the beginning of 2017, I would think, roughly.
And were you involved in the identification of this ambiguity?
Yes.
Was it you within the BBA that spotted this and came up with this interpretation?
I think so, yes.
So what was it that came to change and alerted you to the fact that there was this ambiguity in the wording?
I'm afraid I don't remember it. I doubt if it was an ACM issue because I didn't deal with these materials. Right.
So are you saying that it's possible it came to your attention because of an issue you were dealing with a different product, not an ACM product?
Yes, I think so. Then I probably applied it in the wider context of other BBA certified materials.
Right. And can you help us as to what other product triggered this consideration?
I'm sorry, I don't recall.
Was it some form of composite product with a core in the middle?
I don't know. It may be I was reading the section for another purpose and somehow identified this could be a problem for composite products. I really don't remember what the catalyst was for beginning this conversation with people.
Can you just explain to us your thinking at the time in terms of why it's the reference to etc. in that paragraph that it potentially widened the definition of the materials to cover the core of an ACM?
I think initially the debate centred on whether or not the polyethylene core would constitute a filler. And there is debate about whether or not that would be the case. Possibly it could be argued that it's not a filler, but the fact that there was that presence of etc. within the section, to me, meant that we should look at the purpose behind it and why it was there, and that we should not restrict our interpretation to the rigid definition given within the approved document.
Right. And you say that you say initially the debate centred on whether the polyethylene core would constitute a filler. Can you remember when that debate was going on and who was involved in that debate?
It would have been early 2017, I think. Probably myself and colleagues in the technical department initially.
So are you talking about an internal debate just within the BBA, or were any other organisations involved at that time?
As far as I recall, it was internal.
Was it anything to do with doubts about the safety of some ACMs which had been involved in cladding fires around the world?
No.
Did you have any awareness of such fires in early 2017?
Broadly, yes.
Can you help us as to which fires you were aware of in early 2017?
Not specifically. I think there were occurrences in the Middle East.
I'm sorry to interrupt you, Ms. Grange, but I'd be interested to get Mr. Albon's evidence on a related but slightly different point, and this seems a good time to do it. The actual regulation is not in ADB, is it, Mr. Albon? It's a separate instrument, and it requires the external walls adequately to resist the propagation of fire. That may not be the precise wording, but that's the requirement, isn't it?
Yes.
Did it occur to you to consider whether an ACM panel with a polyethylene core which was highly combustible might not be suitable at any level?
As I've said previously, the BBA is not a research organisation. It's not a fire test laboratory. We are required to identify and apply best practice. So if there was any evidence in the public domain that this would constitute a danger, then yes, I would expect us to be aware of it and to take appropriate action. But I think I think it is for others to carry out the necessary research and place that information into the public domain.
Well, I asked the question only because you were obviously thinking about this sort of problem at the time in relation to the 18-metre limit. And I wondered whether you had thought about it without that restriction in mind, but the answer may be you didn't.
I think my consideration was really specific to the details given in the approved document. I'm really not a fire engineer. I'm not qualified to make a wider reaching judgment on the basis of my own knowledge, I'm afraid.
All right, thank you very much. Yes, Ms. Grange, I'm sorry.
Yes, no, not at all. Mr. Albon, Mr. Locomo thought that the Dubai and UAE cladding fires were part of the reason that the BBA added this height restriction wording. That was at day 107, page 97, lines 18 to 22. Is he wrong about that? That was his understanding, that those cladding fires, those international cladding fires, had led the BBA to decide to refer to this height restriction at this point. Is that right?
Not that I'm aware of, but Mr. Nkomo is a BBA technical expert specialising in cladding materials. I have a different role within the organisation, so he may have been having that conversation with others, but not with me.
But was it you taking the lead in 2017 on making these height restriction changes to BBA certificates?
Yes, on the basis of the contents of the approved documents, though not on specialist knowledge of fires that had occurred elsewhere.
Right. Were you aware of the Lacrosse fire in Melbourne, Australia in November 2014?
I don't think so, no.
Were you involved in the seeking of any external advice or expertise in relation to this point? Did the BBA go outside the organisation and ask for advice from Warrington Fire, Exova, or the BRE at this point about this interpretation?
I don't think we did, no.
Why not? If you're not fire experts and you say that others are much more expert in these matters, why not seek external assistance about the proper interpretation of ADB at this time?
Well, we're not fire experts, but we are quite experienced in interpreting the requirements of the approved documents. And I believe we formed the view that we had sufficient internal competence to make a judgment on this particular point.
Right. Was the BBA aware that there was industry guidance dating from as early as June 2014, which suggested that all elements of an external wall panel should be of limited combustibility to satisfy the main route to compliance in ADB? That was in the Building Control Alliance Technical Guidance Note 18 from June 2014. Was the BBA aware of that?
I was aware of that technical guidance note. I don't know if I was aware of it in 2014, but we would base our judgments on the requirements of the approved documents, which did not have that requirement.
I see. So are you saying you solely looked at ADB, and just on the basis of the language in ADB, that's how you came to introduce this height restriction into your certificates?
I wouldn't say I wholly looked at ADB, but that was the basis of that decision. Yes, I would have thought if best practice was felt to contradict the approved documents, then the experts would have taken steps to update those approved documents accordingly.
Yes, I think what I said was solely looked at ADB. So I was just implying that ADB was your only source of information about this ambiguity, yes?
On that particular instance, yes.
So are you clear that it wasn't any other industry guidance that was instrumental in bringing out about this change of approach within the BBA?
No, I'm not. Other colleagues may have had access to other sources of information, which may have influenced their views when we discussed it.
I see. For example, there's some Booth-Muri guidance from 2016, which refers to all significant elements of each and every layer of the wall needing to be of limited combustibility if following the primary route to compliance in ADB. Were you aware of that at the time?
No, I would have consulted the approved document.
And were you aware of a discussion or debate within the wider construction industry about this ambiguity or anomaly in ADB at the time?
Not that I recall, no.
Now, this is a topic to which the inquiry will return in Module 6, but can you help us at this stage as to whether the BBA ever had any discussions with the DCLG or MHCLG, the government department, about this ambiguity or anomaly that you refer to?
I can't recall any in relation to ACMs. No, I'm not aware of any.
So did you ever have any discussions with DCLG or MHCLG about 12.7 of ADB and its interpretation, including the filler point or the etc. point at any stage?
Not that I recall.
Was this new interpretation of 12.7 of ADB a formal policy or stated position of the BBA?
Yes, internally, yes.
Can you help us as to why we don't see any written documents which record that, which record this consideration being given and this change in approach and the rationale behind it?
It would have been discussed verbally internally with everyone involved and training given to the staff involved as to the reason, the interpretation and the consequences. We don't document every single decision we make within the BBA.
Wasn't this a pretty important decision you were taking from now on to start putting a height restriction for certain certificates based on wording of ADB that was unchanged? It was just your interpretation of it that was changing.
Yes, it was a significant decision. We
So
did
why-
brief everybody, we explained the thinking behind the process to everybody, and everyone involved with the drafting of certificates would have been well aware of it.
So why do we not see any documentation relating to this change of approach?
At the time, it was not felt necessary to document it. As I say, we don't document every technical decision that we make.
Were there any training materials reflecting this change in approach?
No, it was a verbal briefing.
And was this position ever communicated to industry?
I'm hesitating because it was a different team. I imagine when we were changing the certificates, we would have communicated to the certificate holders, but I would not have been involved in that process.
Right. Did the BBA ever take any active steps to implement this change of position? For example, by revisiting certificates it had issued for external wall materials where this change was potentially important?
I think we made the change specifically in relation to ACM materials, and we were going through a process of updating those certificates.
Ms. Amoroso's evidence was that you decided to introduce these height restrictions as and when the certificates were coming up for reissue. Is that right?
Yes.
And what I want to understand is, if you were doing this because you had concerns about the safety of these products and their use over 18 meters, why wasn't this a change that you were urgently implementing across all BBA certificates?
It was our interpretation. It was an interpretation that was not shared by others, such as Dr. Lane. Ultimately, it was the approved documents that were the arbiter of whether or not the product could be used above 18 meters. The BBA certificate has no regulatory significance. And so it was down to the judgment of the individual specifying the product as to whether or not it could be used above 18 meters.
Yes, but let's just focus on what you, the BBA, thought. Were you bringing about this change because you had concerns about the safety of ACM products with a polyethylene core over 18 meters?
I think with respect, you're applying a great deal of hindsight to the questioning. At the time we were making this decision, as far as I'm aware, there was no guidance available to us as to this failure mechanism, the melting, ponding, reigniting of the polyethylene core. The safety criticality of that was not appreciated as far as I know. The approved documents certainly made no reference to it. The approved documents now do specifically refer to the core of ACM materials and require them to be of limited combustibility. That change was not made until 2019. So I think it's clear that this is no criticism of the people responsible for the approved documents, but it simply wasn't understood at the time, the criticality of this aspect of the product performance. Had we known this could happen, of course, we would have made it a matter of urgency.
So is it your evidence that you're making this change, but not on the basis that this is a necessary safety change? What just because you noticed that there was this ambiguity and so you decided to do it anyway?
It wasn't clear to us whether or not the product was restricted. We were taking a conservative view, but we didn't understand at the time the significance of what could happen.
But surely you must have been taking that conservative view because you had some concerns about the use of polyethylene materials above 18 meters. Otherwise, why do it?
Yes, we did have some concerns as to whether or not they would comply with the requirements of the approved documents. And had we appreciated the criticality of that, of course, we would have reacted differently, but I don't think we could have done at the time.
Yes, and what I'm seeking to understand is, given that you did have some concerns as to whether or not they would comply, why not implement this change more quickly?
I think I can only repeat myself that we didn't understand the significance, and I don't think information was available to us that would have indicated the significance of this.
And you're quite sure, are you, that it was pre the Grenfell Tower fire that this change began to be made within the BBA?
I think it was, yes.
And did the Grenfell Tower fire make that work more urgent?
Yes.
Now, after the fire, you prepared a note with Mr. Moore that went to the BBA board. We looked at that earlier, but can we go back to it? BBA 30010485. Sorry, this is, actually, we didn't look at this before. This is the email where Brian Moore sends this briefing note to the BBA board on the 20th of June 2017, so just a few days after the Grenfell Tower fire. And we can see from the top of the page that it was sent to you and others at the BBA. And sorry, actually, I think we need the second email down. Sorry. Yes, sorry, that email there. Mr. Moore says in his email to the board, "Dear board members, please find appended a note regarding the fatal fire at Grenfell Tower. This is our current understanding based on media reports. In summary, we are in a reasonable position." Then it says, if the cladding system, i.e. the combination of cladding and insulation, is as described in the media, then the system is not certificated by the BBA. The insulation itself is not certificated by the BBA. The cladding itself is. The certificate is 2008 vintage and was in the process of being reviewed and reissued just before the fire. We would be in a stronger position if it's stated in terms not to be used above 18 meters, but as the note makes clear, the certificate holder user must comply with building regs. We had not conducted any cladding related inspections at the building. And we can see from the email at the top that then this is forwarded to you shortly after it's been sent to the board. Now, can you explain what you understood Mr. Moore to mean by "we would be in a stronger position if it's stated in terms not to be used above 18 meters"?
Not really. It's his wording.
What, so did you not understand what he meant by that when you saw this email to the board?
I imagine he is stating that from a BBA perspective, if we had said it could not be used above 18 meters, then it would not have been covered by the certificate.
Yes. In your view, should the certificate have stated that it should not be used above 18 meters, given the view that you had formed of the requirements of approved document B in the building regulations?
We were in the process of updating it, I believe, to say that. But it is still the approved document that is the governing document, not the BBA certificate. It's our opinion.
I understand that, but where you say we were in the process of updating it, does it mean, are you confirming that in your view, the certificate should have stated that it should not be used above 18 meters?
I think we had come to the view that the filler, the polyethylene core, would have been covered by the definition in 12.7. So it wasn't entirely clear, But yes, we were saying that. Of course, had we known that it was in fact an E classification, there would have been no ambiguity, and it would have been very straightforward to say it should not be used above 18 metres.
Right. Let's go to the note that was attached to this email of the 20th of June. This is, if we go to BBA 30010486. And I think you told us, I took you to this at the very outset of your evidence, and you confirmed that you wrote this document, yes?
I wrote the initial draft, yes, on a technical basis. It was updated slightly by Brian Moore subsequently, but not on a technical basis.
Right, yes. And if we go to page 3, paragraphs 16, 17 and following, you're dealing with the regulatory requirements in approved document B. And paragraph 18 refers in terms and quotes from section 12.7. And then at paragraph 19, you say, Appendix A defines the meaning of limited combustibility via a combination of test and material requirements. It seems most unlikely from the evidence available that the LDPE filler material used in the composite panels could meet these requirements. There could be some debate as to whether this core constitutes a filler, but we believe that there is a consensus within the BBA that it does. As such, the panels should not, in our opinion, be used at a height exceeding 18 metres, and as such should not have been used on Grenfell Tower. Now, where you say there was consensus within the BBA that it did fall within the word filler, is that right? I thought what you told us in your witness statement was that it wasn't reference to filler that piqued your interest in 12.7, but it was the reference to etc. in paragraph 12.7 that, in the BBA's view, in your view, widened the definition of materials caught by the section. Can you explain for us?
Yes, I think this was written the day after the fire. At that time, I considered that the polyethylene core did constitute a filler. Subsequently to that, I've tried to take on board the opinions of perhaps better qualified people than me, such as Dr. Lane, who believes that it's not a filler. But I still believe the principle applies, that it is not restricted to fillers. The precedence of the etc. widens the definition, and so I think my argument would stand.
I see. So I think what you're telling us is that your interpretation of 12.7 has changed as you've heard more discussion about this point. Is that right?
Yes, partly. Also, I think we were trying to understand the reason for the restriction in terms of the statutory instrument and the higher level requirements.
Right. And just to be clear, prior to the Grenfell Tower fire, and at the time you were scratching your heads and having a good think about 12.7 of ADB, are you saying now that in fact it was the word filler that you thought might cover the core of an ACM panel?
At the time, yes.
But you're telling us now in your witness statement that actually it's the reference to etc. which you think is the better point. Is that right?
At the time, I considered it would constitute a filler. I have tried to take recognition of the opinions of others, but I don't think that it affects the principle of the statutory instruments that materials of this kind should not be used above 18 metres. Right.
Regardless of the filler or the other specific wording in that clause, once the view was held that these panels needed to be of limited combustibility, why did the BBA not immediately take steps to insist that its certificate holders seek to the reissue of their certificates so as to impose an 18-metre limitation for panels that were not materials of limited combustibility?
At the time, this was almost an academic exercise that could be debated as to whether or not we were correct. As I've said, had we appreciated the significance of what could happen, clearly we would have taken immediate action, but I don't think the information was available to us at the time.
I see. So you said you were vaguely aware of cladding fires in the Middle East, and you've accepted, I think, that this was in part driven by safety concerns. And yet, despite that, are you saying that it was acceptable for the BBA not to immediately take steps to insist on changes to these certificates to put in the height restriction?
I was aware of fires in the Middle East and elsewhere, I think, but I'm not aware of any research or subsequent publications that had, if you like, put the blame for those fires on the use of ACM materials and the mechanism of failure of those ACM materials. Had we known that the polyethylene core could behave in the way that it does, clearly we would have taken a completely different view as to their significance. But repeating myself, I don't think anybody did. The approved documents were not updated until 2019.
Did it not occur to you, once you were aware of fires in the Middle East and once you were pondering the meaning of 12.7, that it might be advisable for the BBA to take external advice from properly qualified fire engineers about the risks posed by these panels?
I think if properly qualified fire experts had understood the risks posed by these panels, they would have immediately put that information into the public domain and contacted those responsible for the building regulations.
Well, that's not an answer to my question. Did it not occur to you, once you were aware of fires in the Middle East and once you were pondering the meaning of 12.7, that it might be advisable for the BBA to take external advice from properly qualified fire experts, fire engineers?
I thought at the time, I still think we are capable of making a judgment on the content of the approved documents, which is what we were doing. Had there been other information available to us as to the performance of these ACM materials in fire, of course we would have needed to take that on board, but I don't believe such information existed.
But how did you know if you didn't ask anybody who was an expert in this area?
Because our judgments are based on the requirements of the approved documents, so we would take that as being established best practice.
Let's move on now to some FAQ documents that were issued. If we can go to MET 30531558 _ P18 at page 176. This is a circular that we believe was sent out from the BBA in early 2017 to all local authorities and housing associations. Can you help us? Did you help in the writing of this document?
I would have been involved, I'm sure, yes.
If we go to page 177, we can see there are some FAQs, some frequently asked questions there. And at the very bottom, we can see this statement. It says, as a consequence of the testing carried out, the Rainabond cladding product used at Grenfell Tower was deemed to achieve a Class 0 rating. Now, Mr. Moore thought that it was possible that either you or Mr. Denyer wrote this statement. Do you remember writing that as a consequence of the testing carried out, the Rainabond cladding product used at Grenfell Tower was deemed to achieve a Class 0 rating?
I don't remember, but I'm sure I would have been involved.
Can you explain why the wording is as we see here, that the product was deemed to achieve a Class 0 rating? Why was that used?
I think that's consistent with the wording of the certificate at the time, isn't it?
Well, I don't think we see that wording, deemed to achieve, anywhere in the certificate. I think we see phrases like may be regarded as or are judged to meet, but we don't see that phrase.
Okay, possibly not that precise phrase, but as a principle, I think it's consistent with the wording in the original certificate.
Did you know at this time that, as a fact, Rainabond PE had not been tested in accordance with BS 476 Part 6 and Part 7?
Yes.
Before sending this message to the local authorities and housing associations, can you help as to what steps the BBA took to investigate the basis on which the 2008 certificate claimed that Rainabon 55 may be regarded as class naught or were deemed to achieve a class naught rating? What steps did you take?
At this time, I don't remember.
Now, we heard in the evidence of Mr. Moore about another Q&A document published by the BBA at the time. If we can go to CTAR 6043, it was actually exhibited to Mr. Todd's report at phase 1 of the inquiry. So these appear to be some more FAQs that appeared on the BBA website. And if we look at the very bottom of page 1, these appear to be dated the 22nd of September 2017. Can you see that?
Yes.
And if we go to the bottom of page 4, we can see reference to 2 updates that are given in this particular version of these FAQs about corresponding with Arconic and receiving correspondence from Arconic. Can you help us? Was this Q&A document actually published on the BBA's website?
I don't know.
Were you involved in the drafting of this?
I would have been, yes.
Now, we heard evidence from Mr. Moore that this FAQ was challenged by a whistleblower member of staff, and that shortly after this, UCAS visited the BBA to assess the certificate. Is that right?
Yes.
So did UCAS visit because there'd been a complaint by a whistleblower within the BBA?
As far as I recall, UCAS didn't tell us they had received a complaint. I may be wrong. I wasn't aware of that at the time, I don't think.
Right. Have you subsequently become aware that one of the UCAS visits was due to a complaint made by someone inside the BBA?
As far as I can recall, only through the evidence given to the inquiry.
Right. Now, Mr. Moore went on to say in his oral evidence that you dealt with this member of staff and discussed the concerns that that member of staff had with them. Do you recall that?
There's a slight assumption that I know who that member of staff is and that they made a complaint, but yes, I did have a discussion with a member of staff.
Who had raised concerns about one of the FAQs?
Yes.
Let's just look at what Mr. Moore said about that. If we can bring up the transcript for day 107, page 148, line 6. Day 107, page 148, line 6. Actually, I think we pick it up at line 3. Line 2. The question is asked, and what was the nature of that challenge? And Mr. Moore answers, again, I can't remember the specifics of it. It was dealt with by another director, the commercial director, and the head of approvals, Mr. Albon, met with this member of staff to discuss his concerns. The outcome that was fed back to me was there was a difference of view about the BBA's approach. And yeah, you know, the more experienced, the scientist, Mr. Albon, had listened carefully and given a view. The non-technical salesperson had a different view. And I think the outcome was that, you know, the scientist's view was reasonable and matters were left there. Though I think matters were escalated by the colleague elsewhere, possibly to the media. Now, is that an accurate summary of what happened? That there was a discussion with the member of staff and the outcome was that there was a difference of view, but the scientist's view, i.e. your view, was reasonable and matters were left there?
Yes.
Can you help us? What complaints were actually discussed in that meeting?
I'm struggling to remember the specifics. It was a slightly disjointed conversation. Our colleague wasn't a scientist, had never been involved in the certification process, and as I recall, had a slightly confused understanding of the regulatory situation. His view was that the approved documents were flawed, could not be relied upon, and that the BBA certificate in some way overrode them.
Right. Was that individual also concerned about the frequency of reviews that had occurred in respect of the Reynabond certificate?
We may have discussed that, I don't recall.
Was this a formal procedure, this complaint procedure that was being followed?
No, it was an informal telephone conversation in the commercial director's office.
Was there a record made of the discussions that occurred?
Not by me.
Why
Possibly
not?
by the commercial director. It was an informal conversation.
But why don't we see some record of the complaint that was made and the response that you gave to that complaint?
I wouldn't describe it as a complaint. It was an informal conversation between colleagues. If the individual was dissatisfied with the outcome, he could have escalated it in writing. But as far as I know, he chose not to do so. Right. Had he then expressed it in formal terms, it would have been documented in a different way to a casual conversation between colleagues in an office.
Right. I see. I want to ask you now some questions about the UCAS reviews that took place. Now, it's right, isn't it, that the BBA is accredited by UCAS as a certification body, is that right?
Yes.
And specifically, and you've explained this in detail in your second witness statement, UCAS accredits the BBA to certify wall and cladding products and systems, and ACM materials fall within the scope of that accreditation, is that right?
Yes.
And is it right that as part of their accreditation of the BBA, UCAS would do regular surveillance and assessment of the BBA?
Yes.
And typically, how often do those assessments occur by UCAS?
They are annual assessments for each of the accreditation standards for which we are accredited. There are 4.
I see. So every year, each of those 4 standards are assessed by the UCAS. Is that correct?
Yes.
Yeah. Now, shortly after the Grenfell Tower fire, there were 2 UCAS assessments. As far as we understand it, and can you confirm, there was one visit on the 12th of July 2017 that was solely in relation to certificate 084510, the Reynabond certificate. Is that correct?
Yes.
And then there was a second visit on the 15th of August 2017. And that was after the ACM certificates had been reissued with the height restriction wording on them. Is that correct?
Yes.
And that second review, the scope of it related to the reissue of that certificate, as well as other reissued ACM certificates. Is that correct?
I believe so. I don't think I was present at that meeting, but I have seen the report. So yes, I think so.
Can we look at the UCAS report for the visit in July 2017? This is at BBA 30100733. This is their assessment report. And then we can see in the table on the right-hand side, 3 lines down. Well, it says, sorry, in the middle it says BBA, and then type of assessment on the right-hand side, it says accreditation extra visit. So was this visit outside the usual surveillance that UCAS would conduct of the BBA?
Yes.
And at the time of this assessment report, did it mostly or indeed entirely concentrate on a review of the BBA's records for certificate 084510? Can you help us?
It was a combination of examining the records and verbal examination of the people involved.
Did UCAS look at all of the technical files for this certificate at this time?
I don't recall we would have provided anything that they asked for.
Right, so you can't help us as to whether they saw the whole file?
Not of the specifics, no, sorry.
If we go to page 3, where we have the executive summary, in the second paragraph down, in the third line, we can see that you were present and representing the BBA at this assessment, yes?
Yes.
And if we go to the third paragraph down, it says this: during the opening meeting, it was confirmed that the UCAS lead assessor, Carrie Randall, previously worked for the BBA and had left the organisation 5 years ago. During his time at the BBA, Carrie worked within a number of different sections, including the section referred to in this report as S3, under the section head Jeff Gurney. It was explained that the UCAS head of construction and physics, Sam Giles, was in attendance to address any conflicts of interest that may arise in connection with this and therefore maintain UCAS impartiality. All present at the opening meeting agreed that the assessment could go ahead on this basis and no conflicts of interest occurred during the assessment. So just to be clear, the UCAS lead assessor, Carrie Randall, had previously worked in the department which had responsibility for the Rainabon certificate, yes?
Yes.
Is it common for former BBA employees like Mr. Randall to end up working at UCAS?
I'm struggling with the definition of common, sorry. I think there are 3 or 4 ex-BBA members who work for UCAS. Right,
thank you. And is it right, Mr. Nakomo referred to Mr. Randall as the cladding expert while he was at the BBA. He said in around 2011 and 2015, that was how Mr. Randall was referred to, as the cladding expert within the BBA. Is that correct?
He certainly had a good working knowledge. I'm not sure he was the expert as such, but yes, he was competent in that area.
The fact that he was an ex-employee of the BBA and in Department S3, which issued certificate 084510, is a plain conflict of interest, isn't it?
It could be interpreted as such. It's really a question for UCAS, I think, not the BBA.
Wouldn't Mr. Randall have had an interest in defending the processes by which he himself would have operated?
Well, he wasn't involved in this assessment as far as I recall. Again, I'd have to refer you to UCAS for that question. It's their decision as to who to appoint to this investigation.
Yes, well, I'm sure we can ask them in due course, but I'm just interested in what you can help us with about this. Did Mr. Randall take a full part in this assessment? It says here that he was the lead assessor. Did he, in fact, take a full part in the assessment?
I think he coordinated the assessment. I would say it was led by Mr. Patterson, who was the UCAS fire expert.
Right. Can you explain, just going back to what we see on the screen, if we look at the last sentence of paragraph, that third paragraph down, it says there, all present at the opening meeting agreed that the assessment could go ahead on this basis and no conflicts of interest occurred during the assessment. That reads as if it was both the BBA and UCAS that agreed that the assessment could go ahead and no conflicts of interest occurred. Is that right?
I think we had no grounds to object to Mr. Randall being present at the assessment, so yes.
I appreciate you might have no grounds to object on one level, but did you think that there was a conflict of interest in terms of Mr. Randall conducting the investigation when he'd worked in the very department that had issued this BBA certificate?
Sorry, with respect, it's really not a question for the BBA. We are not here to appoint those who are going to judge us. If UCAS were happy for someone who had left the BBA 5 years ago to take part in this investigation, I see no reason to object.
I see. Now, just to look at some of the feedback that was given by UCAS during this assessment, if we can go to page 14. What we see in this finding, what you get is a kind of finding number, and then in the right hand side you get a justification for clearance or request for further evidence, and it says this: draft of the updated certificate 084510 provided that includes more representative front page photograph, improved front page summary of behaviour in relation to fire information, and clearer reference to product application for use on buildings up to 18 metres. Now, those changes that are listed there, changes to the image, to the front page summary, and the reference to the 18-metre height restriction are some of the changes that we see in the certificate on reissue on the 4th of August 2017. Can you help us? Were those changes made as a result of the feedback from UCAS in this assessment?
I believe the changes were already being incorporated into a reissue of the certificate prior to this assessment. With the possible exception of the photograph, I'm not sure about the photograph, but I think the others were already being agreed.
I see. So it's just coincidental that those were also changes that the BBA, that UCAS were requesting.
I don't think it's coincidental. I think they are confirming that the changes we are making are proportionate and appropriate.
I see. If we can go to page 6 and look at the bottom of the page. There's a header in bold. There we go. There we go. We can see it says certification documentation 7.7. And in the third paragraph down, it says the certificate content was reviewed during the assessment. Particular attention was paid to the section relating to fire performance. The front page summary of the certificate 084510 under behaviour in relation to fire does not summarise all main classification data. It only included the national surface spread class 0 for England and Wales and low risk material for Scotland. Therefore, it is recommended that it would be better to either include all classification information or keep the headings and refer to relevant section with all the information. And then they say recommended finding, and they give a number for the finding was raised in connection with this. So is it right that at the time of this assessment, UCAS were critical of the front page of the certificate, and in particular what it said about behaviour in relation to fire?
Yes.
And UCAS said that that summary should either provide a full overview of the classifications or just a reference to the section in the body of the certificate where fire performance is dealt with.
Yes, but they were confirming judgments the BBA had already made as part of the reissue process. They were looking at the original certificate, not the ongoing draft for the reissue.
I see. So are you saying you had already worked out that that summary needed to change on the front page?
Yes.
Right. And if we go up to page 4, at the very top, there's a heading conclusion. It says this, under conclusion, it says, during the assessment, it was seen that the information included within the certificate was supported by appropriate test data, and that the surveillance processes in place had identified when the content of the certificate needed to be revised. And then underneath the bullet point list, just a little bit further down, we can see it says, overall, it was seen that the BBA have followed their processes in relation to the certification activities undertaken. It was also noted that the processes follow compare well to the requirements of ISO 17065, and that the current processes included good demonstrations of the effectiveness of the processes and systems to meet the requirements of that ISO. Now, when it says that the BBA have followed their processes, is it right that what UCAS was looking at was whether the BBA had complied with its own processes and procedures?
Yes.
And then it had considered those processes against the relevant ISO 17065 standard?
Well, they would do that as part of the original assessment, of course, before they award the accreditation. But yes.
Yes. Did UCAS evaluate the assessment and review process in any detail?
I think it was a 2 or 3 hour meeting. I don't completely recall. So in some detail, yes.
So it did evaluate the review process, did it, in some detail?
I'm sorry, it should say in the report what they looked at. If it doesn't, I'm afraid I don't recall the details of exactly which documents they examined.
Well, can you help us with this? Because we can't find this anywhere in the report. What, if anything, did UCAS say about the BBA having closed the 2015 review without having received written confirmation from the certificate holder that there had been no changes which would invalidate the certificate?
I don't recall them commenting on that.
Would they have been aware of the multiple written requests to give confirmation that there had been no changes that invalidated the certificate that the BBA had made of Arconic?
They had access to all of the information and documents that have been provided to the inquiry, so yes.
Now, clearly at this time, neither the BBA nor UCAS knew that Arconic had a great deal more test data about Rainabond. Did the BBA and UCAS discuss the information on the certificate and how it actually supported, or how it was supported by the test data available?
Again, I don't recall details of the conversation, but I'm sure they would have done, yes.
Can you help us as to how UCAS came to the conclusion that the surveillance processes in place had identified when the content of the certificate needed to be revised?
Sorry, could you rephrase that for me, please?
Yes, what UCAS have come to the conclusion in the report, we just read it, that the surveillance processes in place had identified when the content of the certificate needed to be revised. And can you help us as to how they came to that conclusion?
Presumably from a combination of examining the documents retained on the file and verbal examination of the individuals involved.
But if they mean the surveillance done by the technical assessor, that process, that surveillance process, was not designed to identify new fire performance data, was it?
No.
Yes. Now, after this UCAS assessment, as we know, the Rainabond certificate was reissued. And do I understand it correctly that you reviewed that certificate before it was reissued? Is that right?
Yes, I was involved in the process of updating all ACM certificates at that time.
And if we could just look briefly at what you say about this in your second witness statement, if we can go to that at page 37, BBA 30100723, page 37, paragraph 154. You tell us this at the bottom of the page: the second issue also removed the wording that the panel may be regarded as having a class 0 surface, as it was recognised that this was open to misinterpretation. And then you say amended the presentation of the fire results, but not the results themselves, and updated other wording in line with the then standard BBA format. Now, can you just help us where you refer, if we go back to the bottom of the page, you say you've removed the wording about the class 0 surface as it was recognised that this was open to misinterpretation. What was that misinterpretation?
That all versions of the product could achieve a class O surface when we did not have fire test data support that assertion.
Yes. Had the UCAS assessors said something about that statement, or was it the BBA's own decision to change that?
We had decided on the revisions that were required, as far as I remember, before UCAS made their visit.
I see. And in fact, what we know is there was another reissue of this certificate shortly after this. If we just go to that at BBA 6049, right at the bottom, we can see it says that the date of the second issue was the 4th of August 2017, but then 2 lines down, the certificate was amended on the 22nd of September 2017 to remove ST panel. Can you help us? What does that mean, ST panel there?
For some reason, we've referred to the polyethylene product as standard throughout. And so I assume the ST refers to the polyethylene or standard panel.
Yes, I see. And at page 7, what we see is an updated table. And what we can see in the top of that page in the table is that you've taken out all references to the PE panels, and this certificate only refers to the FR panels, yes?
Yes.
And we understand that this change was made at the request of Arconic following their decision not to sell PE cord Rainabond ACM at all in the UK. Is that your understanding?
Yes.
Yes, thank you. Mr. Chairman, the next phase of my questions are all about the K15 Kingspan.
Right.
I'm very happy to begin those now and go for the next 8 minutes up to the lunch break. Or we could break now and come back slightly before 2 o'clock.
How are you getting on? How are you getting on generally?
So I'm getting on well. I think I've got around a half day to go with this witness. If we go well this afternoon, we may fit it in this afternoon. If I run into tomorrow, that won't be by very much, but I'm certainly ahead of time, given that this was supposed to be a 2-day witness.
It sounds to me as though we could be slightly generous to ourselves and stop now and return at 2 o'clock, unless you tell me that would be unwise.
No, I'd be entirely content with that, and then I can take the topics
All right.
Without breaking.
Well, there you are, Mr. Albon. You get a slightly longer lunch hour today. We'll stop now. We'll come back at 2 o'clock. And again, as I've said to you before, please don't talk to anyone about your evidence or anything to do with it over the break. All right?
Okay, thank you.
Thank you very much. We'll see you at 2 o'clock then, please.
Okay.
Thank you.